Good morning, and thanks for joining us here on Condo Solutions every Monday morning from 9:05 or 6 or 7 or 8 or 9 to about 10 o'clock or so. We talk about condos and HOAs and some of the things that you may need to know. Try to give you some information, help out, address some questions, and maybe be there for you. So I don't know if we fall into the category of essential workers, but we're out now and we're able to give you a hand. So my name is Mark Breckbill. I'm a CPA and a licensed community association manager, and have been dealing with condos and HOAs for some 25 years from a professional standpoint, and have do audits, taxes, financial statement work, consulting, and of course CAM work for associations. The show itself is a community service program to answer your questions, and the person that you call for is on the line with us is Peter Mullengarden. Peter is our attorney who has been in this area, practicing in this area, and now is a specialist all of a sudden. But we all know Peter was a specialist from way back and was an expert in this field, and he's got tons of years. He's been doing this since he was like in diapers or something. And so he's been doing this forever. So he knows what's going on and will help you out. We take your calls. It's a call-in show. And I know we have a caller that we'll get to in just a second. But it is a call-in show. 220-9788, 220-WSTU is the number for the studio here. And Evan will pick it up and get you on the air. We ask that you give us a name, something to call you. It doesn't have to be yours. We're not going to check it out and, expose you if you don't give us the correct name. We don't need the association. And as we always say, we kind of prefer not to have it because that allows us to address the question and have other people who maybe have a similar problem but aren't in your association not tune out the answer, because a lot of times it may pertain to them. It's also why we kind of talk a little broader around the issue because somebody may have the similar but not exactly the same issue. And then the only caution we have, or the only warning we give you, is that you can't take our advice or our answers to court, so to speak, because we don't have your documents. And so if you've got a situation where you need somebody to really give you a hard and fast legal answer, you can get a hold of Peter directly or your attorney, and they'd have the documents and they can advise you directly. And I just say as a note, and I know Peter would chime in on this as well, that sometimes if you're getting advice from your attorney and that attorney is in the arena, that's your attorney, and you should go with your attorney. There's nothing wrong with kind of getting a second opinion, but keeping in mind that your attorney may have more information than we do. And so our answer could change if we had all the information that your attorney had. So we're here just as an extra resource to help you just in case. So that's all the caveats in the morning. That's why it doesn't start at 9:05. It could take like 10 minutes to do caveats. But anyway, that's it. And that's really the basis of the show. We're here to help you is what it's all about. So Peter, I'll say hi this morning, and then I'll get right to our first caller. Morning. Barbara, go ahead.
Hey, good morning, guys.
Morning. Thanks for calling.
Morning, Barbara.
All right, Mark, I hope that your next business isn't going to be making face masks, because what you put on there didn't...
Oh, you saw that? I like that, right? It's a little tough to talk with that on, but yes.
All right, here's the question. I've been trying to get the audit from our treasurer, and he keeps saying it's not ready because the state changed the due date from the audit from March 1st to I don't know when. Is that true? Did the state change the date for the audit completion?
Yes.
The state extended the time period. That's correct.
Yeah. So I think they extended it. Peter, do you remember? I think it was June 30th, wasn't it? But I'm not positive.
Well, they extended it for as long as the declaration of emergency is in effect,
Okay.
and that was just extended for another 60 days.
All right. Yeah. So yeah, that is the case. And I will tell you, to some degree, it was for most audits, I should say, kind of all of them, but for most audits, you've got to have contact with some of the personnel, and you got to go out on site at some point and get information. So it was causing a problem. Some of the auditors weren't able to get to the records, and they knew they weren't going to be able to release the report, or if they did, they would have to give what's called a scope limitation. In other words, they would have to issue a report that was qualified because they didn't have access to all of the records. So that's why the extension was done.
Okay, but the date is March 1st, and we didn't even begin to recognize the severity of the situation until the end of March. So I'm just kind of a little bit surprised at that. But okay, I'll take. Naturally, I'm going to take.
Well, actually, I mean, I think the state, the governor issued his declaration of emergency on March, I believe it was March 8th. Okay, and that was for 60 days, and that was just extended on Friday for another 60 days. The division issued its order on March 27th, if I recall, extending the time period for the for preparing the audits. So.
And Peter, what about HOAs? Does that I think there was some question, right? Because technically the division doesn't have.
Yeah, there's a question as to whether they even had that authority to do it. They did it,
yeah.
But we don't even know whether they have that authority to do it, but they did it anyway. So we're not even sure how enforceable that is, but it's out there.
Okay.
All right. Second question, just real briefly. There's very few people, namely two to my knowledge, the president and the treasurer, that are allowed to speak to the law firm. And as a result of stuff that we have previously talked about regarding that annuity several months ago, which has stalled right now, we have some concerns that we are not able to, some of us are not able to have any conversations at all with our lawyers. How would you address that?
I'm sorry, say that one more time. I apologize.
Yeah. Here it is, Peter. Here it is, Peter. I'll give it to you. Their association has indicated that only the president and somebody else can talk to the attorney, and which I'll say, Barbara, by the way, that's not uncommon, because typically you don't want board members calling the attorney and running up charges that the rest of the board doesn't know about. So having some restriction as to who is able to make contact is not unusual. But so in this case, Peter, she's got a situation where they've got the two people that can have contact with the attorney, but they were the ones that she had called previously, and they were the ones that the board was trying to basically put their money into annuities. And they had some concern, and she had some concern about that, and she's trying to figure out how can they address that with the attorneys if the people that are designated to do that won't let anybody else talk to the attorneys and won't bring it up with the attorneys.
Well, they might not be able to do it through the attorneys. Okay, I mean, lots of boards do, and my own clients do it, where the board will authorize only so and so or so and so to have the authorized contact with the attorney, which is, like you say, which is fairly standard. So if the question is, how does a person reach the attorney?
Well, how does the association or some of the other board members address this issue that they want to address with their own legal counsel about the ability for the association or to invest in annuities, and the restrictions?
Well, anyone can go to their own counsel. Any individual owner or individual director can contact their own attorney on their own dime and get an opinion. But is the question about how does someone on the board reach the association counsel?
Yes, that's the question.
Okay.
That's the question.
Well, that may be difficult. Any board member can obviously send something to the attorney, and the attorney will most likely share it with, his contacts on the board. I think the one way to the way I would probably address this is, I would send the board a certified inquiry by certified mail, in which they are required to give a substantive response within a certain amount of time. That time varies anywhere from 30 days to 60 days, depending on how they do their response.
I would.
But I can't. But there's no iron, surefire way to, allow you or anyone else to necessarily speak to that attorney. I mean, if they have the authorized contacts, it doesn't mean that you can't still. There's many avenues open to challenge the association. You might not be able to speak to the association attorney per se.
But Barbara, I would do, what Peter's talking about. I would send that a written inquiry to the board by certified mail, return receipt. I would send that out.
Copy the lawyer on it.
Copy the lawyer on it, and send your copy to the attorney, certified mail, return receipt, so that you'll know that the law firm got it. And then they may not be able to act on it, but they'll have had it, and they'll have at least opened it and probably read it. So, at that point, they'll know that there's an issue out there. And most attorneys, if they know there's an issue, they may not have but they're going to contact their client and ask them, what's going on here.
Well, I am on the board, and another woman and this other woman has the actual original signed, sealed, stamped, and recorded documents and of our association. And we have found out that the legal firm that represents the association does not have the original documents. And so because of the situation that came up, we were assigned to go through side-by-side comparison of our current documents with the actual original documents. And there have been a number of important things that have simply been disregarded, including the terms for board members. That was changed, and no change in the amendments, no change in the documents, nothing ever recorded. So we have come up with a report, and because of the nature of it, we feel that we should be able to not only bring the original documents to the lawyer, but discuss some of the things that have been systematically eliminated from the current documents.
Well, how large is your board?
Excuse me?
How large is your board, Barbara?
15.
Oh, okay. So it's going to be difficult.
Well, any attorney that represents an association should have a copy of the current recorded documents. Now, they may not match the originals because the originals get amended. So, and those amendments get recorded. And the attorney, he or she, should be working off of the current set of documents as amended.
Correct, and that's what we have. That's all the groundwork that we have done. We have traced every single recorded document and compared them with some of the documents we're now working on, and some of the documents we're now working off of. The stuff was never recorded.
Yeah, I've seen that happen. more than you'd like. I've seen a number of situations like that, but I had one not too long ago where the association had put something together it was kind of the opposite situation. They had put something together as a proposal, but decided to table it. Never went to the members to get approval to modify the documents, but forgot that they didn't do that, and then slipped that stuff into the documents they were giving people as the approved and filed documents. So, I think sometimes it happens by accident. The case I was talking about, I think, did happen by accident, so to speak. I think that something happened and they just didn't realize that they didn't have the final approval on that particular, because they had done a couple of amendments. But anyway, I mean, it's, with all of that information, you as a unit owner have the right to request a copy of the documents from the association. you have a right to request that information, and the association has to send you the filed documents. If they send you something other than what you've got, then I think you've got a basis to challenge what you've got and have them show you why their documents are right and yours are wrong. And I think that should be addressed. If the association is working off of an incorrect set of documents, there's all kinds of certifications that are given, that you've had the documents and you've had a right to them, and you could request them from the association. You have a right to. If because they don't have the current amendments, or maybe they have a property manager who doesn't have the current file, or whatever. I think those are the kind of things that members, not just board members, but members should and do have the right to challenge, to make sure that they're following the correct documents, both the members and the board. So, and I think the kind of the suggestion that Peter had in terms of how to address some of that. And if you've already done the legwork, but I would give them a chance to provide documents again that they say are the association documents, because maybe somebody pulled stuff out, and maybe the attorney's keeping the actual documents, and one of those documents the association didn't have, or whatever. But I'd give them the benefit of the doubt initially and just say, look, I'm trying to, I need a complete set of the documents as filed for our association, and make that request. And then if that doesn't turn out to be what you guys have, then I would send a letter to the association board and to the law firm, just indicating what's going on, because the attorneys are going to want to know if there's bad sets of documents out there. That's a problem for them. It's hard to enforce stuff when when the association has been handing out documents that aren't the association's documents. You get into all kinds of issues down the road. So I'm sure that's an issue they'd want to know about.
Okay, I appreciate it. If I may take another moment,
Sure.
I'll give you an example. Our condo association is part of a property association, multiple condominium associations. So when the property association was formed, our bylaws were supposed to be amended, and and the attached exhibit to the formation of the property association stipulates that at our annual meeting, each condo section will elect their representative to the property association. And that has not been followed, and the person who is the representative claims that since it's not in our particular bylaws, it doesn't apply to us. And my position is that when we became a part of the property association and we accepted the rules, regulations, and bylaws as stipulated by the property association, that in fact meant that we were abiding by that particular bylaw that said that we got to elect our representative. And that the property association document further stipulated that particular bylaw was to be added to our bylaws in our particular section, and it was never done. So this is where my concern about resistance is coming from. Tabish?
Yeah, that I know what you're saying. Is it the way it's written? Is that the association elects the board, or elects the board of the POA, or is it the members vote to appoint the board, the association's board member to the POA?
The associate actually is technically, apparently, we are not considered a POA, but strictly a property association by name. I do not know the accuracy of that statement. That is what I've been told. But the each section gets a representative, and that representative is to be appointed by the members of that association at their annual meeting.
Okay.
And that is not done.
Yeah. So the property association was created after all the condos were?
Correct.
Okay. Actually, I have a couple like that. It's kind of weird.
Yeah, that is. I know of one like that too. But
And normally it's done. It's not at the same time, or the POA is not actually done first.
well, and normally if the POA, if all of its members are condos, then it becomes a condominium association.
And usually it's treated as a condo.
Right.
Yeah.
But a lot of times, especially up here in Martin County, what they used to do, because you couldn't get, if you got approval for a project up here to start building, and if the board of county commissioners changed, you might all of a sudden find yourself with phase 1 built and phase 3, 2, 3, 4, and 5 aren't going to get built. And you got all these amenities you can't pay for. So the builders up here, the developers, I should say, used to, they'd get all the phases approved at once. So they'd go approve phase 1 through 5. And they would be controlling those out of a master association. And what they would do is make it so that one of the phases was not a condominium, because if any one of the phases is not a condominium, then the controlling association, the property owners association, becomes a HOA type association, not governed by condos, and so it wasn't under the same requirements.
All right, but in this case, if I understand this correctly, the POA bylaws expressly provide that every constituent condo association elects their representative to the POA board, right?
That is correct.
At their annual meeting, I guess, or something like that,
correct.
Presumably.
Correct.
All right, and what someone is saying in your association is because your particular set of bylaws doesn't say that, then they do it differently. Yeah, I mean, what, their board? I don't understand. Their board picks the rep, or how does?
Yeah, that's the crux of the problem.
Well, I think. Look, I'm not. Again, we always have that caveat when we start the show. We don't have your documents and that kind of thing.
Right.
But here, I think I would probably go with, the bylaws for the POA expressly provide how their board is selected, and to me, that since that is that particular corporation's procedure and that's their bylaws, I think that would likely control, even though it's not expressly in the constituent condo bylaw.
Apparently, it was supposed to be added when the property association was voted on, and it was recorded. The statement was this would be the addition, and this was the bylaws for each section were a different exhibit. And then, according to the instructions in that exhibit, the bylaw was to be added to the individual sections' bylaws. It never was. But since we are part and parcel of that property association and abide by the rules and shared common expenses, to me, it seems that that the bylaw does apply to us.
Barbara, what does the association?
I would tend to agree with that. I'm not saying this is the most, because I have some similar situations. I'm not saying this is the cleanest in the world, but I would tend to agree, that the POA bylaw would be the one that would control.
Barbara, what does the POA actually own? What's its common property?
Well, the entrance. This was done. This place was built in the 70s,
right?
And there was simply proposals for additional sections. And so the property association controls the lift station. They pay for the lift station, the guardhouse, the boulevard.
But if
the security, things like that would be divided amongst these sections.
Yeah, but the thing I'm having a hard time with is that I don't see how it got formed after. I mean, you would have to have a conveyance of common property at some point, potentially.
Yes, there is, with all the easements, everything that's all in the original document. All the easements, all of that. Be that as it may, I don't know how. All I know is I have the recorded documents. We have a property association. We have meetings. We split the costs. They get to elect their representative. We don't.
Huh.
And it's a concern because what we have here is a concentration of power, bluntly put.
Yeah.
So who elects your rep from your condo?
We don't.
You don't have a rep.
we have a rep, but we don't elect the rep.
So your representative is picked by your board then?
Our sort of, yeah.
Okay.
Okay.
Now that's possible. I mean,
I don't know. I mean, again, I don't want to get into whether the whole setup is kosher or not kosher or whatever. That's really not for this forum. But
I understand that.
I think I would probably err on the side that if your association. By the way, now are all the individual unit owners members of the POA, or are the corporations the corporate members of the POA, or do you know that?
Correct. The members are not, by virtue of being a member, a part of the association. It is the corporation that is a part of the association.
Well, if the corporation's part of the association, and I don't think you pick and choose what part of the bylaws you're gonna be part of. So again, without getting too deep in the rabbit hole, I think I would most likely be erring on the side of that these particular bylaws run this particular association, and these bylaws expressly provide that each of the constituent corporate members elect their rep through their own members. Where each condominium owners elect, and that's what I would go with. Now, again, all this stuff, ultimately, I can have my opinion, you can have your opinion, Mark can have his opinion, even though we don't care about Mark's opinion.
Yeah, that's right. Mine doesn't count. I'm just allowed to.
But seriously, at the end of the day, they're just opinions, okay? And the only way to try to get some resolution, if it ends up being an impasse or a disagreement, is through either a arbitration or court procedure where they shake it out. Sounds like the condo should be electing its rep through its owners, but if there's disagreement on that between you and the or other owners in your condo and your board, again, the only way that's going to be resolved, if at all, is either through some mutual agreement and you move on, or through some kind of dispute resolution, arbitration, or court.
This goes back to my initial question. I would like that's why myself and another person who did all this legwork, we would like to meet, and she is also on the board. We would like to meet with our lawyers and go through these documents with them, so that they are aware that they are in fact, and they have.
Well, like we said, I mean, you could, as Mark said, and I think I said too. I don't know if you'll be able to, for lack of a better word, force a meeting.
Okay.
Quite frankly.
Okay.
I mean, what you could do to kind of at least push it along, as we mentioned before, is through the certified letter to the board, copy the attorney, make some inquiries, at least compel them to respond, and then go from there.
Okay.
Notwithstanding the political issue, which is change over the board and get yourselves in a position to make more decisions. But that's a political thing.
Yeah, and the bigger the board, the harder it is to move them. That's
right.
You got 15 members. Really. You're going to have 8 people. So you've got. It really is. I mean, that's the purpose of one of those large boards. I will tell you, that's the exact reason that I've seen associations, POAs like this. A lot of times, the way I've seen most of them done most effectively for what the association was trying to do, is that the property association, the security association, whatever it happens to be called, it has members. The members are the corporate entities, and the corporate entities appoint their representative. There is no member vote. There's no vote at all, because the individual associations, they elect their board, and their board, as part of their capacity as a board member, has the right to appoint the representative to the security or the POA or whatever it's called. And as a result of that, you have because there's only 3 members or 10 members or whatever it is, in your case 15 maybe, you have the ability to make changes you could never make with associations. I mean, it's the maximum amount of flexibility you could possibly have in a condo or HOA situation, and I've seen those done very effectively for what they're trying to do, and that is to be able to make changes to the association without having to have 100% votes of all of the unit owners plus plus their representative, plus their mortgagees and all that kind of stuff. So so I've seen, I mean, these kind of situations do exist pretty commonly, to try to do it, to try to control those kind of things. And they, a lot of times, not all the time at all, but in many cases, the membership is the corporate membership. Now, typically, and this is something to look at, what kind of lien rights does the POA have? A lot of times in those corporate situations, the POA has the ability to lien the association, which is kind of interesting. So, so you might look at that too, because there could be a gap there in terms of being able to enforce any actions taken by the POA if the POA can't enforce their dues. So I would also, take a look at how that's structured.
One battle at a time.
Yep.
Thank you very much, gentlemen.
Nope. Thank you,
All right.
Barbara. Good questions. Thanks a lot.
Thanks, Barbara. Have a good day.
You too. Yep. Yeah, those are kind of interesting, Peter. Do you have many of those? I've got.
I have a couple. In fact, this sounds real close to
Well,
if it was one of mine.
It was very close to one I've got too. So
It's
real,
real close. But anyway.
Yeah, I know. It's because there's a lot of those kind of situations out there, I think. And you know that.
Well, it's always odd, and I think what happens, when it's done kind of backwards, where the master association, if that's what you want to call it, you can call it a POA, you can call it whatever you want, but
right.
when they record the master association after the fact, either the
Right.
developer changes his development plan or whatever happened back in the 60s or 70s, and now you're basically, creating, because this association after the other associations, which kind of runs counter to typical property law, where you have to, where you can't subject something to some covenants without the consent of the, of the owners, which is why it's always done first. So you buy in already subjected to it. So then you're trying to create this, system, kind of backwards. But, then you have the documents that and I guess in this case, don't quite dovetail with each other. So it does create issues.
It's funny though. I know a lot of times in a lot of those things, like I say, in Martin County, it's kind of different up here because then for example, St. Lucie County or Palm Beach County, because we've always been such a no growth county up here that when the pro-growth boards would be elected, the developers usually had projects on the table that they were ready to try to get, because usually everybody was clamoring for more housing. That's why there was an election of new commissioners. So what would happen is, like I said, the developer actually would set up the master association and would set up, and it would be phases. And so there'd be one phase that was being built, but there were still 4 or 5 or 6 more phases down the road. And in many cases, particularly in a situation where you're talking a POA and you're talking not subject to the typical turnover timetable, you had a master association that actually was formed before everything else, but it doesn't actually finalize until years down the road. And and the associations have turned over, and they've sold out and moved on to the next association. Like I said, the trick in those days was the developer always left the homeowners association, townhouse project that was a home that wasn't condos or whatever. Always left that to the very end. And then what would typically happen is they may not build that phase. That phase may, something else may happen with it. And then the master turns over because it no longer has any property. And then you've got this master association, which is a property owners association. And it does have, it still has control of all of the other parcels in there. And, so it gets complicated, but that's the way it was done up here a lot. And so, we see more and more of those where, people, and they're set up because of the structure. Initially, they were set up for the master to be able to control the associations.
Well, I mean, back when I did developer work in a former life, and I would do my client would do a master with sub-association project. I mean, I don't recall ever doing it backwards. We would always record the master declaration first.
Right.
Okay. And then as each sub-association came in, and those were usually phased themselves.
Right.
Okay. But so then you would record your declaration for, condo 1, let's say, or whatever. And when you did that, at the same time, you do a supplemental declaration annexing that within your master, and so forth and so on. So as you brought property into each condo, at the same time, you would do a supplemental declaration annexing that within your master.
Mm-hmm.
So they would just be all done at the same time. But always the master declaration was the first thing that was recorded, or maybe simultaneously with the first condo deck, and off you go. Doing it afterwards, that's,
I haven't.
Again, I have a couple like that, but it's not normal.
Yeah, I haven't seen many after. I don't know that I know of any that were done after. Most of the ones I know were done in advance, and in fact, all of the phases are declared. That's why those associations used to have trouble with the old phantom units or unbuilt units concept, because
and that was always an error. Okay, quite frankly, because the whole reason to do phases was to give the developer as much flexibility as possible. So, like you said, if 3, 4, 5 years in, they decide, this project's not going to be 1,000 units; it's only going to be 200 for whatever reason,
right?
And they stop, and the phases that aren't brought in are, they do something else with them. They sell them off or develop them as something else. It's usually from a developer standpoint, you don't want to bring all the property in at once.
No,
because then
except in Martin
County.
That's
if the government forces you to, that's a whole other story.
Right,
okay?
and that's what happened here in Martin County. And that's why we have probably more of these type of things that Barbara's talking about here. Although, like you said, Peter, I think more of them I've seen. The master was set up initially, and all of the phases were brought in initially. All of them were declared as part of the association. And the reason was that, here in Martin County, we're Martin County. We actually tore down an apartment building that was approved and occupied. We tore it down because we decided it didn't meet the requirements for transition in the comp plan. So even though the commissioners had approved it, we tore it all down after the fact. So builders, you can understand, are a little bit leery of in Martin County. We're always a little bit leery of going back to the commission, who may have changed by then, to say, okay, we're getting ready to start phase 5, and we've decided to take it from 200 units to 250 units. Or instead of doing single family, we're going to do multifamily. You're never going to get that approved. Never get that increase in density. So they go in initially and do the maximum density possible, and then back off of it, because the county would always reduce density. They would just never increase density. So, which made it very difficult on turnover, because it was hard to force turnover because you never knew exactly how many units there was going to be. Because it was staked out maybe in different phases for a certain number of units, but then as they'd actually start building, they might reduce those. and it was constantly an argument as to, or a concern as to when actually the turnover when actually the turnover would exist. So anyway, it's kind of a screwy thing up here. And Peter, you and I have talked, because I know I've been involved in it, that this all stems back to the fourth district's ruling on the risk case, which was relative to that's RISC, which was relative to the this question of unbuilt units. And everywhere else in the state of Florida, all the other courts in the state of Florida have recognized the concept of unbuilt units, and that the association or the developer had to pay assessments based on those units, except in the fourth district. And we still don't have that in the fourth district. The cases that were designed to overturn them, which was Schooner Oaks down here in Martin County, that was originally going to be a challenge case. And then the state at the last minute had a big changeover in personnel and pulled out of that case and just rolled over. As a result, the risk case stood again. There was another one that was potentially going to be challenged in the area, but in the St. Lucie County area, which would have been the same district. But anyway, it didn't happen. So we still have that. But we've got a caller. Bill, go ahead. Welcome.
Good morning.
Morning.
Yeah, I have a question. We're having a board meeting tonight, and just last Friday they made an announcement that they're going to do it over Zoom. I have a question. Suppose you don't have a computer and you can't access it, the meeting. Is that legal still, or
Zoom can be done but via phone. You don't have to have a computer. So if you've got a cell phone, Zoom meetings are either visual or you can just dial in and listen and participate that way and have that. So I know I've been involved lately in a lot of Zoom meetings. I don't have my individual computer that I have in my office. The mic and camera don't. It's an old computer. They don't function right. So I always enter those on the on my cell phone. And since I don't like to look at myself on the cell phone, I always leave the video off. I do it just by phone, and it works pretty easily. It's actually, I think this is one thing that I think that the virus is potentially going to help associations, because it's getting boards to look at some of this technology. And what was happening is many times during the summer, the association would go months without a board meeting. They would have their last meeting in April, and then they wouldn't have another meeting until October or something, or September. Yeah. And you know what? This is pretty easy to do. Members can call in and and join the meeting. You can mute them so you can control the meeting, and then allow people to have questions. And there's and they can do it via phone, via computer. They don't have to be real technologically savvy. If they can get on Facebook, they probably can. Most people today can get on Facebook, but you don't even have to get on Facebook. Zoom's just a program by itself, and it's pretty easy to operate, and it's got a telephone number with it, and you can just call in. So I would give it a shot. I think it'll work pretty good. You don't have to have a computer to participate. It's kind of like technically, for a meeting, you've got to have all it technically requires is a speakerphone that everybody, or a mechanism where everybody can be heard, and you can hear everybody else, and everybody can be heard. And the Zoom without the video is the same thing. You can do that pretty easily. Skype is kind of the same thing a little bit. There's Microsoft Meetings, which is pretty popular. So
although for some Zoom meetings, and this is for security reasons, the host can control who calls in, and actually it has to be a pre-registration.
Yeah.
Where you have to register yourself rather than just leave it open where anyone can call in. So it depends how the host is doing it too.
Yes, that's true.
Right.
And but it is pretty easy for a participant, and if you've got somebody that can host it, knows what, and can get it set up, it's pretty straightforward. I was never a big fan, but I know I've used it now in a couple meetings I've been involved in on the CPA side, and I know my son is using it on a couple of his associations now, so that they can they can conduct business that they need to conduct. And he's been doing the same thing in his association. So I think it's going to be a pretty good way to get things done.
Quick question, Peter. If I go to a board meeting and the president says I can't speak until he gives me permission, is that legal?
Well, yeah, I mean, there is. Well, I mean, someone does chair the meeting.
Insinuates that he can deny me permission, which would go against the 719.
Well, he can't deny you permission. Okay, so that word permission is right. It can be a little bit. That's probably the wrong word. I mean, he could say that you can't speak until you're recognized. Okay, because generally speaking, I mean, as you know, every owner or every member of the association has the right to speak on any agenda item,
right,
or any item that's brought up for discussion. Now, the chairman of the meeting or the chairperson of the meeting does have the ability to control it, so it's not a free-for-all. So, one person speaks at a time, but they certainly are not authorized to not allow anyone to speak, assuming that, you can't, you're not necessarily have to have two turns. You can only, everyone gets their one turn or their one opportunity to speak. So the permission word, I'm not sure if he's implying it, he might not allow you to speak. The better word is recognize, but every owner, whether they have something good or bad to say about the topic, okay, assuming you don't say anything.
I know we're up against the clock, so let me just jump in real quick.
Go ahead.
He says we follow the Robert's Rules of Order, and you need permission to speak, which the word permission, like I say, insinuates that he could refuse permission.
He means recognition.
I think he means recognition.
Well,
okay,
no,
I hope that's what he means.
No, he's saying permission. It's a problem. Like he's trying to shut me off at the beginning of the meeting.
Well, I guess you have to just see how it goes at the meeting. I mean, I'm not going to go hung up on the word right now. The real bottom line is, are you permitted? Like I'm using that word now, but are you permitted to speak on an agenda item? Whether we use the word recognition, permission, I don't really care. But if he's using it in a way to censor people from speaking, that's obviously wrong. Okay,
right. If
he's just using it in a where he meant to say recognition, not permission, I'm not going to get too hung up on it. So it really depends what actually happens at the meeting.
Well, I was being speak on something because you need permission to talk. You're not allowed to speak until I can give you permission. We're following Robert's Rules of Orders, and I got to give you permission to speak. That's wrong as far as I'm concerned.
Well, like I said, I'm not going to get hung up on the word. If you're allowed to speak, I don't really care what he calls it. Okay? So I think he's meaning recognition, but I'm not sure.
But
all right. Thanks for your help anyway. I'll call next.
Okay.
Thanks, Bill. We'll get to it. The thing about that, and I know we're running out of time, is that the fallacy in that law is that there's nothing that says that you have to be allowed to speak before they vote on the item.
But you should be. That's the way it should work.
But unfortunately, that law needs to be shored up there. But I know what you're getting at. So anyway, well, we appreciate the calls, Bill, Barbara. Appreciate your calls in here, and everybody out there, appreciate you joining us. We'll be back again next Monday right here on WSTU between 9 and 10 o'clock on Condo Solutions. And you are listening to WSTU Digital 1450. We're Martin County's very, very old station. Thanks for joining us.